And Mr. Sharma, whenever I take the file in chambers, many new things tumble out. And I don't know why the lawyers of the petitioners don't read the files and come and make their start their argument. I don't know. Now, you see, please see the trial court records. So this is second file. I think you'll have to go down.
Yes.
Ms. Verma, please see that. Ms. Verma, you please see this. Ms. Verma, please see this because I'll need your comment, all three of you. Now, in this, after some pages, you will find the judgment.
Yes, ma'am.
Correct. Now you see in the certified copy, what is there in paragraph 13 is in the original record, paragraph 12. How it happened, we don't know. Paragraph 13 of the certified copy, it is flagged. Correct. Not only that, we are interested in this paragraph 12 or 13 only. Now you see, please read this paragraph 12 here and 13 here.
12 to পড়া থাকে
After scrutiny,
It may be pertinent to.
If so, it would mean that he was born sometime in the year 1951. In that case, he was not eligible for free in the year 1970. Therefore, admissibility of such voter list of 1970 is questionable. During cross-examination, DW2 stated that his father died before 1997 and he has never casted his vote along with his father.
Correct.
Yes.
That is the statement. Now come to the written statement.
Written statement, that is what?
Paragraph 4, 5. Antabali is given. 4.
yes.
Right?
Malikpur Moja.
In the evidence on affidavit also, same paragraph 4, name of the father Antabali is mentioned. Correct.
Yes.
Now, in the original record, you will find after this judgment, second page is Form B, Form 2. Now, in the Form 1, 2, 1 and 3, father's name is not there. Correct? In the
Yes.
judgment also, the father's name is not there.
Yes.
Now, in Form 2, at para 13, there is referred and Altab Ali.
Yes.
Now the tribunal is saying that you did not deny it and therefore you are a foreigner. Is it not stretching it too far? Now look at the summons Form 2. There is not mentioned that this Form 2 was given to the petitioner. So this will be a perverse judgment. And it appears that the burden of foreigner is on us. So we burn our midnight oil.
No, it can never change, we say. I'm wondering that 11 to 18. 11 is insofar as that is 10 numbering to relation of the office. Discussion before
One clarity.
and to reference due to these cases.
Sure.
Three
Reporting.
only issue. No,
And you see,
way to
even the court, even the tribunal,
Yes.
as well as the lawyer of the petitioner, as well as your side. Nobody assisted the court in telling us, you see in the original record, the evidence is there after a few pages.
I think 8 to 3
Correct. Now,
days.
what has happened? There are 3 witnesses examined.
Yes, Lordship.
In the order sheet, I'll tell you there are 15 dates in the order sheet. In none of the order sheet, the AGP is shown to be present. In the judgment, in the top, it is written so and so for the AGP for the state. Now, this AGP's submission is not recorded anywhere. There is no hajira of the APP, AGP, and the cross-examination is in the back page of the evidence. It is examination. He was not even cross-examined. DW 1 and 2, they were not even cross-examined.
Three.
Runner 292.
Back page of the evidence. On examination,
It is not a fact.
correct. In the order sheet, you see corresponding order sheet is not a cross-examination. Examine. Therefore, in examination, there is a confirmatory statement. How do you make the procedure a foreigner?
Process ही तो फेंके भी लगेगा ना.
And in every case, we don't have time, that much of time to read,
Yes, Lordship.
and there would be injustice.
Actually, I think these take into, I think matter that's in this one.
We start by saying that we'll dismiss the matter and then we read the matter, it's totally different. Only 3 has been cross-examined on oath.
Only.
And this examination, please see, there is no oath given.
Hmm. Full process.
All procedures sent to
Or his
sent to Sky.
Lordship can make this observation, send this matter back, asking them to follow the complete procedure, Lordship. Because there are the loopholes, Lordship. And serious loopholes.
No, but the issue is again, this is the point we were both deliberating. Why a remand? Because we are exercising jurisdiction under certiorari.
Sure.
Therefore, we are posing a question to you. You respond to it at 2 o'clock. Because if the tribunal does not follow, then why remand? Tell the matter on this. Because we can't permit this. The tribunal does not even know what is examination, what is cross-examination.
Lordship may take up this matter to put up some directions for the tribunal's Lordship, and the thing which we have been discussing, that more training, more orientation is required for the members. This is a fit case for Lordship to interfere and bring in all those things, Lordship.
It's okay. You give a suggestion. If you don't want to give it in the open court, in the chambers, you can come and
Lordship, it is nothing to, it is what I'm stating, I would be discussing that only with Lordship. Our members do need training, more training, Lordship, especially when they're following these CPC and evidence, law of evidence, Lordship. And there is no, nothing to hide, saying that they need to be more trained, Lordship, more training is required. They need to look into the process, procedure, like Lordship has pointed out. Process not there, but it is reflected in the
Judgment.
opinion. Then in the order sheets, the Hazira is not there. So if in one particular case, Lordship brings out everything, the other members will also get alerted, Lordship. And this is the right case for Lordship to interfere and bring in everything.
And
Let the
we see
government also know
in the
how the members are performing, how the state correspondent councils are their Lordship. Because there is no supervisory power over them. Nobody is doing it.
And one more question. In the state government, who is the authority, uh, who is in charge of the foreigners tribal matters?
When political B department, Lordship.
Home and political B.
Bureau. And what has fallen from Lordship ought to have been done long time back. It was happening recent few years back, but of lately nothing has been happening on these issues.
Yes.
So what happened was because of proactive role by one of the honorable judges at that time.
Yes, Lordship.
So there was an entire exercise in the administrative staff college, and then these
Yes.
training sessions were held.
And it helped them, but now since it is not there and nothing is being followed up, there has to be some follow-up of these members also, Lordship.
In fact, the my lord, monitoring bench recent
Okay. After a week.
Deeply
Item
applied.
3.
Please, Your Lordship, I beg to mention item number 5. The matter may be listed any other day, Lordship. I'm praying for an adjournment for the day.
Why?
Lordship, 2 matters have been listed for hearing, and my senior will appear for the other matter, and this matter may be taken up any other day, Lordship.
Okay, after a week.
So, bless Lordship.
Yes.
Wait, please, Your Lordships, Lordship, item number 6, kindly adjourn the matter.
Item?
Item number 6, Lordship.
Okay, allow. Yes.
Obliged.
Daily list item 1 for hearing.
Which page is the opinion?
My lord, page number 16, annexure 1. 1-6.
Yes, but then you don't have any document to connect you to your projected parents.
My lord, page number 28 is a 1997 voter list, my lord, where the mother's name and the petitioner's name is recorded in the same voter list. And 2011 voter list, page number 30. There's a direct linkage, my lord, with the mother and then father. And also father's name is written, my lord. Page number 28, my lord.
This is which exhibit?
This is, my lord, page number 1997 is exhibit J, my lord. Exhibit
This
J.
page 28 is exhibit J.
My lord, 1997, according to this impugned order, it's exhibit Z. And
Page 28 you are saying is exhibit J.
my lord, yes, according to the impugned order, my lord. It's mentioned in the impugned order. And 2011 is exhibit C.
No, page 28 is not J.
No, my lord, page 28 should be J. Page 30 is exhibit C. Lord, I'm reading from the impugned order also. It's mentioned there.
Please check up.
Oh. Hold on. Which is G, not this. It is 71. Billing capacity. Billing capacity. My lord, page number 28 was an annexure. Because there was different voter list 1997. That was J, my lord.
No, no, that we don't know because we are reading it from the evidence. It doesn't match. You are showing 28. 28 doesn't match.
Yes, yes, your lordship is correct. But 20, page number 30 is annexure D, my lord. Yes. 2001, 11 voter list is annexure D.
No, annexure doesn't matter because it's not proved.
Exhibit.
Exhibit C 2000.
You see, in your case,
My lord,
exhibit E, F, G, K, and L,
my lord,
they have no value. So now there's only remains
my lord, my lord.
the voters list. And voters list, there are so many judgments says that it is not a proof of citizenship.
But my lord,
Because when it
Annexure
comes to
6
the names of your parents, you say that the names of the parents were wrongly recorded. And you give an affidavit.
but the same parent's name recorded in 1966 and 70, my lord. Also, my lord, the mother appeared as DW2, my lord. My
Now they
name has
appear at DW2.
DW2, my lord. DW2 is page number 46, my lord. The PP was not there. She was not cross-examined. My lord. My lord, here, he was not cross-examined because there was no government law. There's no PP in this case. No one appeared for the government side. Page number 16 in the impugn order, it's written, my lord. Advocate for the petitioner, none. So the deposition is undemolished.
No, but page 42 reflects that it's a cross-examination.
My lord,
You come to page 42,
my lord.
this is cross-examination. In the top, it says taken by court. Then there are 3 cross marks. So this is a cross-examination by the court. Tribunal has done it. Page 42.
Even though it remains undemolished, my lord, probably the tribunal has done it and not the government lawyer. Tribunal cannot cross-examine others.
No, you see this, that is the same thing we were expressing our anguish.
My lord, my lord. The tribunal cannot
You,
do
you
that.
say probably they have done it, but you are not sure. You are not read the brief. We are better read than you.
My lord.
Then you see, that is a different thing.
My lord,
Whether something has been proved, not demolished.
My lord.
But if the tribunal has discussed it and dismissed it,
my lord.
is it so wrong? Haven't you heard any case where a writ petition or a revision filed by party without the appearance of the opposite party or respondent,
I know.
or a suit without appearance of the defendant has been dismissed? A complaint case under 138 may have been dismissed even without issuance of notice. So how do you demolish the finding of the tribunal?
Your lordship has, I think, 2 months back passed a judgment. I would like to get that judgment, my lord. It is. I now remember, my lord. Your lordship has passed a judgment on this, on whether the tribunal can cross-examine or not.
Shows.
Today, it's not with me, my lord.
Then don't start an argument. If you're not prepared, you're not prepared.
My lord, my lord. My apologies, my lord.
You see, 50% of the subject I know. I can give you a random a discussion on various aspects reading from the AR manual. Doesn't help us in the case you either have to be prepared or you don't have, you are not prepared. After every question, if you take an adjournment, it may take years to hear the matter.
My lord is correct.
Today I have one query. The finding the reasons are given. The documents of post 1971
My lord.
can be ignored for the time being. So the document which you approved, which is prior to the cutoff date,
66 and 70.
is Exhibit A,
Exhibit A and B, page number 20.
1966 and 1970.
My lord.
But then every other document fails.
My lord, but page number 30, my lord. This was exhibited, my lord.
30.
30, my lord. This is exhibit D, my lord. There is a direct linkage, my lord. Yeah, mother's name and daughter's name is written.
You see, you come to page 22, or rather 23. It's Muhammad
23,
Muhammad Khan.
Muhammad Khan,
Muhammad Khan. Correct.
my lord.
You are showing us page 30,
Muhammad, my lord.
Muhammad Ali.
Page number
And you would know better. Khan will not write Ali.
my lord, can I take your lordship through page number 26?
No, but you have personal knowledge. Normally, Villa Khan.
It's written Muhammad
Uh,
Ali Khan.
Well, that's okay, but Khan will never write Ali. There is a historical background. But yes, Mr. Payang, the village is same all throughout, except for the name, Sophia Khatun, Satya Khatun.
Lordship may kindly see, that is the point, my lord, your lordship may kindly see the examination part of the DW1, my lord.
DW1.
Yes. That is
Page 39, my lord.
59. That is perfectly. May I read, my lord, that particular? So this has was some, my lord. I was born and brought up at Kumudi Paria, the district of Barpetia. That is the village, my lord, where the is producing the documents. I was married to Makbar Ali, son of Terepali village 34 years ago. This point has to be seen, my lord. After the time of marriage, at the time of marriage, I was 18 years old. My father, Mohammad Khan's name appeared in the voter list of 1966-70 at village Komolipara under Barpeta district, exhibit A and B of the voter list of 1966 and 70. Now, my father and mother also appeared in the voter list of 89-97. After the death of my father about 26 years ago, we shifted. My lord, my lord, this may be seen in the original, my lord. After the death of my father about 26 years old, we shifted from Gahi to Kumalipura. This is wrongly written. My lord, this is not after the death of my father about 26 years ago, we shifted from Gahi to Kumalipara. Not to Gahi from Kumalipara.
Galia. L-I.
Galia
No,
to,
this is village Galia,
yes,
and they say that from Galia to Komolipara.
yes, they have shifted just 26 years back from 2016. So their existence in Kumalipara, the petitioner's existence in Kumalipara is only from 26 years back. So it cannot be 66, 70.
We don't know. This is something, you see,
But I'm,
if the page you are reading, page 42.
yes, my lord. Your lordship may kindly see page
No, no,
42, yes.
we'll show you something.
This is by DW1, man.
Correct.
After the date of my,
No, in this page 42.
Yes.
The age is 52 years.
yes,
This was recorded in the year 2016.
2016, my lord. So
2016
2016, 26, my lord.
minus 52 will be 4.
No, my lord, 2016, before 26 years.
No.
So,
The age would be,
yes, my lord.
birth date would be, year would be 1964.
Yes, my lord.
Correct.
Yes.
1964. And they are shifted
26 years back from 2016, my lord.
16,
Yes. It is 1990, my lord, maximum.
1990.
Yes.
Yes.
And she has brought documents of this Kumulipara village to where, my lord, he has, according to her, they shifted in 1990 or around 1990, my lord, we can say around 1990. She has produced documents of 66, 70 of this village. She has admitted that much. She shifted from Kahi to Kumulipara due to erosion of the Peki. We are now second aspect, my lord. She has produced a Buddha list of 2011 along with her mother. But according to her, she got married 34 years back. When she was 18 years old. Now, in this same paramalot, she has, in fact, she has stated, as she has no, they have no brothers, my lord. She is residing with her mother even after marriage. But the next para is more demolishing, my lord.
Just a moment. Yes.
Not in
What is the
next,
second point?
second point, my lord, your lordship will find it the same in the next. However, in the same para, my lord, down below, she has stated that as she has no, they have no brothers, my lord, she is residing with her mother now. That she has stated. But next period, my lord, I have casted my vote in the year 1989 at village Gahi,
Galia.
Galia. There is no document of this, my lord, 1989 at Galia village. In fact, there is not a single document of this Galia village. My lord, after
Annexure 3 and 4. Annexure 3 and 4. 1989 voter list.
shifting from Gahi to Komolipara, I was marked as D. He was marked D in Komolipara, my lord.
At Galia.
At Galia. I have annexed the voter list of 1989 and 97 as annexure 3 and 4. I have my vote at village Kumalipara along with my mother Sophia Khatun, husband Makbur Ali Khan Ali in 2011 after shifting from Gahia to Kumalipara, and I have been casting my vote in 2011 and 2016. Now the entire story, my lord, here is different. According to her, my lord, she has her father and mothers all were along living in the my lord, this Kumulipara village since 1966 and 71. And there they have voter list and documents. Now in cross-examination, whatever your lordship may, for clarification, if we can accept that it is a clarification of from the my lord, the court, my lord, or the tribunal, she has revealed that my lord, she has come from Kumulia village, this Kahi village, when her father expired along with mother, shifted to Kumulipara. These facts has, my lord, occurred only in the cross-examination time.
Village, where this Kahi village came, which
Galia, my lord.
Galia,
This is not
Galia, huh?
H-L-I.
Galia.
Yes, yes.
My lord, what happened, what my understanding is, in Galia, my lord, from this document itself, she has been declared, my lord, she has been identified as the voter. Now, to evade that, my lord, she has come to this village and stayed along with that projected mother. And there, my lord, she has been casting vote in that village from 2011 onwards. Now, these facts were not disclosed at the time of my lord,
No.
either in the evidence or in the my lord,
My lord, page number 34, I have
Judge,
clearly
don't
mentioned.
interrupt. Yes.
Yes, these facts were not disclosed, and these facts were, my lord, not disclosed because this person was declared D. To evade only D, she came to this village, and there she has enlisted her name, where she is casting her vote regularly. From this situation, my lord, from this para, it reveals, my lord. And this projected father and grandfather, my lord, mother, who were there in this village from 1966 to 70 as her parents. Otherwise, she would not have said, my lord, they have shifted from Gali village to Kumalpur. That is the truth, my lord.
Yes.
My lord, this is not true actually, my lord. I would like to take your lordship through page number.
No, let him complete.
Oh, I'm really sorry.
But, so, yes, my lord, the petitioner, even though relying the other documents, my lord, the consent certificates, that is not proof. And only document therefore to link herself to her mother is, my lord, 2011 voter list. And 2011, as your lordship has seen, my lord, the projected father is Mohammad Ali. And the voter list of 1916, 66 and 71 is, my lord, Muhammad Khan. That is clear. And to link herself to that Muhammad Khan, who is there in 1966 and 71. To link herself to that Muhammad Khan, who is there in 1966 and 71. My lord, there is no other document. And if we may accept the story of the petitioner, what she has revealed in the cross part, my lord, it cannot be accepted that the, my lord, person whose name was appearing as, my lord, in 1966 at 17 Kumolipara village is her father and mother. Because she was never before, my lord, in Kumolipara prior to, my lord, 1990. And her family, my lord, and her family.
Okay. That's all.
That is the point, my lord.
Yes.
My lord. My lord, page number 34, my lord, is the WS. Page number 34, para 10, my lord. May I read, my lord?
Yes. Yes.
My lord, para 10, my lord, page number 34. It
Yes.
says the second party's own name appeared in the voter list of 1989 along with the husband as serial number 241, house number 82 of village Galia. So her name was there in Galia. Under 44 number Jania LAC, and second party's own name also appeared in the voter list of 2011, an electoral voter ID card at Kumaliapara. And second party was shifted to village Kumaliapara from the village Galia along with her family member due to erosion of river Beki. The second party's name was Mark D, doubtful disputed, in the electoral of 1997 of village Galia under 44 number Jania LAC and also subsequent voter list of her maiden exercise of the franchise. My lord, there is no reason to believe that she hided some fact. There is absolutely no reason to believe. Here she has already mentioned that I am a D voter in village Galia, where she was married, my lord. And my lord, she says that I was married some 36 years ago. So by that date, it was 1982 when she was married, when her age was 18 years, my lord. So then, my lord, the minimum age was 21 years. So her name could not have been recorded in the village Galia, in the Kumalipara, the place of her birth. She has categorically mentioned in the earlier page, my lord, page number 32, that the second party was born and brought up at village Kumalipara. She was born at Kumalipara, married at village Galia, and then shifted to village, her own paternal home, my lord, when the father died, and also because of the river erosion, which has also been, my lord, corroborated by the mother. So one, she did not suppress any fact. She clearly said that have been marked as a D voter in village Galia, which is also, my lord, in the LCR. It is there, 1989 voter list is there. There is one issue, my lord, and I agree that her name was there in two places, my lord. in two places. Probably because she was there, and her name was not omitted from that voter list. But when she came to her paternal home to live with her mother, as stated that she has no brother, that is why she came here, and also because of the river erosion. So here her name was recorded. And in 19, which is page number 28, although it's not exhibited, my lord, but it shows that her name is there in 1997 voter list also with her mother, and 2011 voter list exhibited exhibit C, my lord. So absolutely no suppression of facts. She clearly states everything. This is crystal clear, my lord. Probably that I came here 26 years back, my lord, those kind of minor variation do happen during the deposition, my lord.
Is geography is a very good subject.
My lord.
Geography is a very good subject. The net shows that the general elevation of Galia
Galia.
in Borpeta is 47 meters. General elevation from sea level of Galia in Borpeta district is 47 meters.
What does that mean?
We don't know, we just, we are not commenting anything. We're just saying geography is a very good subject. Okay.
I'd like to submit two judgments, my lord, on section 50.
Yes, what is that judgment?
My lord, this is because the mother deposition is very clear. This is one judgment is Suzab Ali, another is Karim Ali. So just to read like the relevant paras in Suzab Ali, page number 17. Triple 2020 WPC, page number 17, my lord. Para 15, my lord.
Yes.
May I read, my lord?
No, we have read it.
My lord, also in that Karim Ali, my lord, it's 52, my lord. Para 52. The Manupatra prints, my lord.
This is paragraph.
This is paragraph number 52. 52, my lord. The last page.
Yes.
Now, my lord, page number 46, my lord. the deposition of DW2. Here, Sufia Khatun says Malika Khatun is my daughter. Now, this clearly comes under this statement is by the family member, her mother, a mother whose name is there since 1966. So one, through exhibit C, she proves her relationship with the father and the mother, and also through oral evidence, my lord. Now, my lord, here I want to add another point. Had Malika been a Malik, had she been a male, her name would have been there with the parents since when she turned 21 or 18. But because she is a female, my lord, she was at her husband's place. She had to come to Kumalipura from Galia, though she was born at. So there is, my lord, an indirect discrimination on women when it comes to proving citizenship, because they are always behind male, my lord. Although on the face of it, the entire structure is neutral, my lord, but there is an indirect discrimination on any female petitioner, my lord. That's why, my lord, because there is 2011 voter corroborated with 1997, although it has not been exhibited, but it is on record, and the oral evidence.
Discrimination is something which is never pleaded and not even forwarded. This is not even a prayer that you have been discriminated. Rather, under the foreigners matters,
My lord.
there are certain listed documents which, in the wisdom of various authorities, they have accepted it. It can't be said that the acceptance of the documents to prove citizenship for females would be discriminatory. Who has prevented? Who has prevented that, or who is in your family directed that at attaining age of 18, you will become a voter in the husband's home? If
Normal
father did not kick you out, or mother did not kick you out of the house, they would have made you voter in their own house. So it is the family matters, how discrimination of the state comes in.
My lord, may I say this, my lord? May I submit? My own sister's name is still at our home. She has not taken away to her husband's place. But in most of the cases we see, my lord, hardly in
That is a
any
family
case there is
process.
a parental
We
home.
can't interfere. You see, you check up, there is a recorded history of, the recorded matter of Jonathan Lee Riches.
Right.
You find out in the net. Name is Jonathan Lee Riches. He started his career by suing his mother, saying that the mother did not take good care of him when he was young. And he won that case. Correct. So issue of discrimination will come when you sue your mother and say that she allowed you to be a voter outside her home. But how does the state come in?
No, that's why, your lordship, I said that the state is not directly discriminating. There is an indirect discrimination, my lord.
We
The
don't know.
entire system is facially neutral, my lord.
It's your family business.
There is not,
We can't make a
prima facie,
comment.
there is no direct discrimination. This is an indirect discrimination.
We can't make a comment.
In the Navtej Johar, my lord, that was the Supreme Court, Honorable Supreme Court coined that term, my lord.
It never related with the voters.
Yes.
Issue was not a voters list.
No, that is, your lordship is correct. But I'm saying that principle was coined in that.
No, that's why you see, otherwise, had we not been impressed with your argument, we have not shown you Jonathan Lee Riches.
My lord. My lord, and then I leave aside my indirect discrimination argument. But, my lord, there are documents. I have not suppressed anything, my lord. I have clearly stated that in my matrimonial home, I was a D voter. I came here to my parental home, and then my name is there, 1997, although not an exhibit, it's an annexure. 2001, it's an admissible document. And then the oral submission, my lord, of the mother, direct, my lord. And it comes under Section 50 of the Evidence Act.
In these documents which you have annexed in the writ petition,
My lord.
which are the documents which are not exhibited? Please point out those documents which are not
Uh,
exhibited.
One is 1997 voter list, my lord. 1990 from the village Kumalipara, that is one.
Give the page numbers.
my lord.
Give the page numbers.
Here in this writ petition, my lord, page number 28. Page number 28, my lord.
Yes, 26 is a approved document.
My lord, page number 36.
26. Is it approved document?
Beg your pardon, your lord.
Is page 26 a document proved by you?
Page 26. Okay. Yes, this is in 1989. This was also not exhibited, I guess.
Any other document which is not an exhibited document?
Not an and my lord, we have not annexed most of the document which has not been exhibited, my lord. Lord, as far as this writ petition is concerned, 1989 voter list, page number 26 and 28. These were not exhibited, my lord.
Okay.
Well, I also want to cite some judgments. But I also want to cite some judgments, my lord. Well, first of all, I would like to cite, my lord, this Sobananda Sunwal 2005, 5 HCC 665.
One.
Yes. 5 HCC 665. Para 26, my lord. What needs to be proved by the petitioner? That must. Pointing out on para 26, my lord. That's because there is no clear guidelines or rules, my lord. So this become rule for the entrepreneurs tribunal after this judgment, my lord. So one needs to be proved by the proceeding that is given to Sobananda Sunwal 1, my lord, 2005, 5 SCC 665. para 26. Other issues as I'm not coming, madam, para 26, what needs to be proved that much? So we have to see whether the proceeding has able to prove. The 5 facts which was given, whether the proceeding could prove these 5 facts, my lord, which were given by this in this para. That has to be seen, my lord. Yes, ma'am.
Yes.
Para 15. Once the the list person. Can you write? Yeah. Fine. Out matter 1970 and then matter 7. What is 2018 until
Just a moment. 2000, I'm just trying to find out 2002 for SCC. For SCC.
Para 15.
and the 2018 183. Pasiron, ASIR. There are 30. It's 60 miles. It's it can be. We want to use. But let's now with those posters which are in there, that may be accepted. Poster who is favoring them, it may be ignored. That cannot. If we like the voter list of 1966, 70, that's Mohammed Khan, he has to accept it. He can say, if he says Mohammed can be accepted, Khan may be ignored. That cannot be. Except the 14th part. There are 30. Thousand 5, there are 47. There are 1095 zero, 1. From there are 10, 71. 1095 zero. 1091 GLT7. And from Perak 10. And here is my line. If I claims that he father those with his that has to be established in such a manner doesn't lead to any other aspect. A different person. That aspect has to be point out, or that has to be come out from the evidence that he may not. That Mohammed Khan did take care of anybody. So if he claims that I'm the son of or daughter of that Mohammed Khan who is there in 19. That has to establish in it. And there should not be any ambiguity. The alternative can lead to someone else. That point is established. But then. But last. Not 100 trillion. Evidence matter. Personal.
Usually, I put in GLT citation. Again, also take the GLT citation. Yeah. That is-
Mr. Payang, you might have already gone through this judgment of the Honorable Supreme Court, Rahim Ali. Whatever you have submitted, it's been para 40 and 41. It has been taken care of. These are all, Supreme Court has held that it is minor discrepancies.
But my lord. Your topics.
Not only that, spelling also. Spelling also, it says,
Surname.
yes.
Surname is the
No, it doesn't say surname, it's spelling.
spelling. Here, my lord, in the present case, it is surname is changed.
It says only on the ground of mismatch of actual English spelling of the names and discrepancies in the dates.
This is not a spelling wrong. Surname. I am Payang, my lord. Not my Payang has been changed to Ole. That is not the my lord correction. That is not a spelling mistake.
We don't think so. I think
Surname has changed by present case by not in date. Upon apex status, let's say suffix and prefix. And the minor spelling mistakes, minor spelling mistakes,
have you gone through the judgment?
that has been taken care of. Surname is not taken care of. But my submission is that Madam Khan has become Ali now. Khan, not Khan. And my lord Khan has become Kha. That has been different, my lord. And the spelling mistake have been accepted. Mohammed maybe my lord changed, sometime Mohammed may come, may not come. That may be different. But Khan cannot become Ali. And that has not been taken care of. Actually, this is. Suffix and prefix I accept. It's minor spelling mistake. Mohammed may become something. Muhammad. That can we accept, my lord.
Please.
Yes, you know. It is the only documents where the petitioner is appearing now with it. Now, 9 years ago, in 2011, they have admitted. Well, this is the documents where I was appearing. And at like 59 years. They have also admitted, well, this is enumerated later on, after marriage, coming back to this village. This is not a normal phenomenon. It's proceeding, well,
What is list of
2011.
2011? Okay.
I think it was 39 years, mother. And they have admitted, it is after marriage, she went to different village, then coming back to village, and intentionally making this name, putting their name in the voter list of 2011. One thing, your lordship, I have submitted up. When she was declared in that village, he has not said these things. He might not, in the production, might not be while enumerating this much. Have disclosed she had the bona fide. Have disclosed while entering her name in the voter list in this 2011. This shows she has no benefit.
But I have mentioned in the WS one.
Only in 2011. And
If you have to say, you say it, you complete it, then he will ask him to argue. Please don't interject.
My lord,
This is the third time we are telling you in this case.
my lord, my apology.
If you don't have respect for the other side, don't be here.
My
As simple as that.
that aspect has to be. Not a normal. Would the petitioner could have enrolled in the voter list in before that? What my submission was then earlier also. That we want some document. This is earliest to the petitioner. Earliest, we connect the petitioner along with parents. At least the earliest document. Some earliest document to connect the petitioner along with. And this document connect projected parents, my lord. So we accept it. Accept it's a very good matter. Then, my lord, only at the age of 39 years. Now the second ask my lord. Is not. I am citing. To Supreme SC 7. 2022 SC 763.
What is the name?
Sanjoy Wise. Central Council for Research,
No, actually.
Ayurvedic Science. Central Council for Research in Science and Pranab Das and others. I have paragraph 50 onwards. Onwards.
This is the definition of okay.
In power of research. Now, 112 of the
Okay.
power of research.
Let's not be, close the matter then. Close the matter then.
May I just say one line, my lord?
Yes.
My lord, I have submitted another Sirazul Haq, which is also reported to 2019-5 SCC 534. Supreme Court judgment, my lord.
This is 2019.
2019-5 SCC 534, para 3 and 4, my lord. My lord. And also, my lord, my linkage is both parents, not just with Muhammad Ali Khan, but with both the mother, which is there since 1966, and it has been taken care of by Rahim Ali, my lord. There is some discrepancy in the spelling, but that has been taken care of by Rahim Ali. That's my humble submission.
Okay. But Mr. A.W. Aman, learned counsel for the petitioner. Also heard Mr. Election Commission was there. T. Pegu on behalf of AIRD, Study Council for respondent number 2. Mr. J. Pang, learned Study Council for the Home Department, representing respondent number 3 and 5. And Mr. R. Talukdar, learned Government Advocate, appearing for respondent number 4. There is no representation from respondent number 6. Most of arguments are concluded, judgment is out.
Obliged, my lord.
Item 2.
Wait, please, your lordship.
Yes.
In this case, my lord, the petitioner before lordship has been declared to be a foreigner of post 71 stream. My lord, on the ground of my lord discrepancies in names of her father as well as herself. As per the petitioner, my lord, name of her parents, my lord, were recorded in the 1966 voter list as well as 1970 voter list. Because you'll find the voter list at page 14, 96 voter list, my lord, 66 voter list. Page 14.
Where is this DW two?
My lord,
DW two.
yes, my lord. PW2 is the cousin of the petitioner, my lord. First cousin. Mother of the petitioner and the PW2 were sisters, my lord. Probila and Nikyu, my lord, sorry, my lord. Is the Nikyu. Oops, cousin.
Yes. You want to
Plus
go through it? Do that.
In both the voter list of 1966 as well as 1970, names of the parents are reflected. And in the land holding certificate, my lord, the name of the petitioner is connected with her father. Only there is a discrepancy in the name. Instead of Sona Bhanu, it has been written as Sona Khatun. If you'll find the voter list of 1966 at page 14, my lord. Haran Sarkar is the father. Mukuljan Desai is the mother. This is the voter list of 1966. Then the 1970 voter list also you'll find at page 16.
Yes.
Then also you'll find the voter list of 2005, where the name of the petitioner was recorded along with her husband after her marriage. 2005.
Which one?
2005 is 18.
2005 is not an exhibited document.
Yes, it was exhibited, my lord. Yes, it was not exhibited, my lord. But my lord, her name was reflected along with her husband in 2005.
It's an exhibited document. No. There are only 3 exhibits, 5 exhibits. 1966, 70, landholding certificate, revenue paying certificate, Jamabandi.
Yes, my lord. So, my lord, if the landholding certificate, my lord, was will find,
That is a secondary evidence, it is not admissible.
my lord.
Landholding certificate,
My lord, this is a public document, my lord.
pardon me?
Public document, my lord.
No, it's not a public document. You will never find a landholding certificate in the government records. You will either get a Jamabandi or you will get a Chitha. Landholding certificate is an extract from somewhere. Prepared by the mandal or the circle officer.
But my lord, this
So he'll have to
document
come
was-
and prove it.
this in cross-examination, my lord, this document was not exact, my lord, questioned by the state,
No, was the author of the document examined? No, I don't find.
my lord.
Author of the document was not examined.
They have not, my lord, questioned the validity of this
No,
document.
you see, just a thought. You, for some reason, give the certificate to your colleague counsel. Correct. Now, you substitute yourself with a circle officer. Circle officer gives your colleague a certificate of landholding. Is that a document of title?
If it is unquestioned, my lord,
It's an extract. You could have got a better document. 61 and 63 says document evidence should be direct. And
my
what you
entire
call-
case, my lord, rests upon this landholding certificate. Because my entire case, my lord, rests upon this landholding certificate. But that apart, my lord, in Form 2, it is the case of the state that I am the daughter of Haran Ali Sheikh. Haran Ali Sarkar.
That has also been explained in many judgments.
It is not that, my lord, I am not the daughter of Haran Ali Sarkar. It is the case of the state that I am the daughter of Haran Ali. And in that case, my lord, only burden lies upon the petitioner that Haran Ali is the, my lord, voter, citizen of India. Haran Sarkar.
Yes.
Matlab, as per the prosecution, matlab, state case is that matlab, I am the daughter of late Haran Sarkar and wife of late Abul Hussain. Late Abul Hussain. Then if I am the daughter of Haran Sarkar, my burden lies only to prove Haran Sarkar is a citizen of India. If Haran Sarkar is a citizen of India, matlab, then I will be automatically citizen of India. And name of Haran Sarkar is reflected in matlab, voter list of 1966.
No, no,
as
you
well as
see, I've been asking this many times. Today I searched the net and if he is also doing the same search, he finds the voter list of Z. Correct.
Right.
Now, in the voters list, what is given is the name of the name of the voter and the father.
Right.
Correct. Whether it is right or wrong, we are not commenting right now. But for A to say that he is connected with the voter at voter name Z, he'll have to show from some other documents that he is the son of Z. Merely possession of a voter list, will it make somebody a son of the A? Can he become a son of Z? That is the question. What is this I have or A has? Well, that is a proof of parentship.
normally, matlab, the persons who do not have the landed property, matlab, they have the voter list. And voter list is the only proof.
No, but here you have land. But in the Jawabandi, the entries are of 2017. So the entry into the country prior to 25/3/1970 was not there. Because this certificate, it is your certificate you have exhibited, correct?
Yes, matlab.
Recorded in land is recorded in the name of Sona Khatun, daughter of Haran Sheikh. So the surname changes from Sarkar to Sheikh.
Yes, ma'am. To that extent, matlab, I am relying on a decision of this honorable court, matlab, wherein matlab, this honorable court has held that normally in the villages, matlab, in case of the particular community, matlab, the names are, matlab, there is discrepancy in the titles and names. And that not be fatal, matlab, to deny them the citizenship. This honorable court has held in the case of matlab, Anwar Hussain.
What is the citation?
Citation, my lord, I get it from my lord legal, 2014 legal, Guwahati 986.
Anwar, what is the spelling of Anwar?
ANUWAR. Hussain.
And
My lord,
Hussain?
WBC number is my lord,
No,
WBC
Hussain spelling.
ANUWAR. Hussain, HUSSAIN.
Okay.
Case number is also there, my lord, in the judgment, my lord. WPC 4258 of 2013. I am relying on paragraph 10 of the judgment, my lord. Paragraph 10.
Okay, we'll resume at 2.
My lord.
This is the difference. This is the person. This. Yes, 100% para 10.
My lord.
Yes,
As I said, my lord, the parents of the petitioner, their names were recorded in the voter list of 1966, 1970. And this is the case of the state that, my lord, she is the daughter of Haran Ali Sheikh. And there is discrepancy in the names. And to support that discrepancy, my lord, I relied on the decision of this honorable court, when this honorable court held that, my lord, in paragraph 10, the judgment. May I read the paragraph 10, my lord, on the relevant portion only, my lord. Page 5 of the citation, my lord.
page,
Page 4 of the judgment, my lord.
page 4. Yes,
My
we are
lord,
there.
Fifth line, 7th line, my lord. Insofar, you got it, my lord?
Yes,
Insofar discrepancy in the name of petitioner's father is concerned, it is a common phenomenon in rural areas, more particularly among the people of Muslim community, to have more than one name or there being variation in the name such as the name of the petitioner's father. The discrepancy in the name, as noticed, Samed Ali, Abdul Samad, and Samed, is not so great as to draw adverse inference regarding citizenship of the petitioner. On the ground of there being such discrepancy in the name of the petitioner's father, petitioner could not have been declared as a foreigner. Here also, my lord, in the voters list, name of the father has been recorded as Haran Sarkar. And my lord, in the landholding certificate, the name of the father has been recorded as Haran Sheikh. And her name has been recorded as Sona Khatun instead of Sona Banu. These are the only discrepancies, my lord, that can be, my lord, ignored. And on that ground only, my lord, the Senate Tribunal has opined that the petitioner is a foreigner of post-71 stream. His lordship will find the judgment at page 26. Page 26, my lord. Relevant portion is paragraph 6, my lord, as page 28.
yes,
On perusal of all document, it is found that Exhibit A is the certified copy of voters list of 1966, where the name of Haran Sarkar and Basarat Sarkar aged about 60 and Gopuljan Nessa, wife of Haran Sarkar, aged about 41 years, recorded at village Ramapara Nonke under subdivision Bobeta, and Hormuz Ali, aged about 25 years. Exhibit B is the certified copy of the voters list of village Ramapara Nonke under PS Bagbor, where name of Haran Sarkar, son of Basarat, aged about 64 years, and Gopuljan Nessa, wife of Haran, aged about 43 years, and Hormuz Ali, son of Haran, aged about 29 years, recorded. Exhibit C is the land holding certificate issued by the circle officer, where it is certified that there are 3 plots of land by Dag number so-and-so, recorded in the name of Sona Khatun, daughter of Haran Sheikh. The opposite party claimed that the above mentioned land is recorded in her name, but there is no proof that Sona Khatun, daughter of Haran Sheikh, and Sona Banu, daughter of Haran Sarkar, is the same person. Moreover, The opposite party in her statement has stated that she is now 41 years, and if she is 41 years, then as to why name is not enrolled in any electoral roll prior to 2005. The opposite party also submitted one linked certificate issued by GP secretary. This is not proof, my lord, so my lord, this may not be taken as the linked certificate. So only on the ground of, my lord, the discrepancies in the name, he has been declared to be a foreigner. Validity of any of the document has not been, my lord, questioned by the learned tribunal also, my lord.
No, you see, the issue is not only whether the names are different or the names are not matching. There's also a fact that you can't connect yourself to the parents of to your projected parents.
My lord.
Well, except apart from the voters list, you don't have anything else.
There is no other document.
But then you'll have to show us a judgment, not on the discrepancy of name, but on the fact that voters list is enough to connect you as a son or daughter of the projected parents.
In that case, Lordship will take up this matter on the next week, my lord. In the meantime, my lord, I will
No, we're not,
the husband's.
having
my lord,
heard the matter, we are not closing it. We're not inclined to adjourn it. Because there are a lot of decisions.
Yes,
We're
sir.
well settled on
There
that
must be some
matter.
decision on that point also, my lord.
Because your only exhibits are land holding certificate, certificate of. So land holding certificate, if it. Where is this document, land holding certificate?
Fact that my lord, Haran Ali Sarkar is the father of the petitioner. It is the case of the state also, my lord. And my lord, in their report, they did not say that, my lord, I have come from Bangladesh. They have not mentioned any address in Bangladesh in the report. Form 2 report. Mr. Lordship, there is the Form 2 report, verification report.
You see this, come to page 22. The SMS version of the, is it 23?
23, my lord.
Correct.
Matit Sona Khatun Pita Haran Shekhar.
So
Nijor
here it
namot
says it
Loka
is to
Jami.
certify that Baghpur Circle, Baghpur Moza, Rampathar Gaon,
Yes, my lord.
page 22. So and so Ismaili Patta is as follows. The land is owned by Sona Khatun. Now, if it is a Exonia land, the owner will always have to be government.
Yes.
Because in Exonia land, there cannot be a settlement. It's a government land. You may be holding possession. Doesn't make you the owner. The protection is available in Arunachal Pradesh, where the land belongs to the people. Or for example, Nagaland. But otherwise, Eksunia Pata is annual Pata land. The act says it would be government. Therefore, what happens is that you don't get a Jamabandi for the land, you only have a Chitta.
I'll have to collect the Sita, certificate copy of the Sita also, by the way, in that case, my lord.
That is Exhibit E. This is a Jamabandi. And this land does not match with the land of Eksonia Pata, page 22.
The Jamamandi has not been discussed in the judgment, my lord, opinion, as well as my lord, it was not provided to us also, my lord. Exhibit E, the Jamamandi, my lord.
You know what has happened in this case?
My lord.
No. The land was originally Eksonia Pata. You got a certificate which is at Exhibit C,
My lord.
is dated 26/7/2016.
Well.
Correct. Now come to Jamabandi. The Jamabandi is Exhibit C, E. In 2017, on 25/9/2017, this Eksonia land was settled in your name by payment of premium, and land was settled in your name. Therefore, Jamabandi is created.
My lord.
So therefore, this document, Exhibit C, is a non-existing document, because today when we are looking at it, this was filed along with your evidence when
6
evidence is on
21 February 2017, my lord. 21 February 2017.
Then you see, you just check up the records. You have the entry. I have opened up this page, Jamavanti page. I've also opened up this list of exhibit. This is. This is the.
21 3 26 28 3 1 so evidence code say 20
This is
1 February
16. 15 is different. like this.
exhibit 2 करा बस exhibit 2 exhibit 2 से
You have to give some explanation. You give it to Mr. Saikia. You can both look at it. Look, you see, this is the Firisti by which exhibits are filed. Correct.
No,
What
मतलब
is the
this
date?
this is the मतलब evidence of DW1
No. There's a flag. I
other
put up a
flag.
flag.
Yes my lord
What is the date of filing?
3/9/2016 it says 3/9
30, 39 or
yes
39?
30
39.
my lord
2016.
my lord
Now I opened up the Jamabandi for you. The Jamabandi is an open copy. Read the remarks. Remarks. Last column. Read that.
25/9/17 order is 25/9/17
17.
yes my lord
Correct.
yes my lord
So in 16, this Jamabandi did not exist.
yes
Then how did you file this
Then
document?
16 it doesn't exist but my lord the
In 16, the
documents were
document was not there.
documents were exhibited by DW2
We don't know. The document in 16 was not there.
yes
The order of settlement is in 2017. The document is not there.
yes but it has been proved in original
We don't know, but it couldn't
How
have
could it be
existed.
proved my lord
It couldn't have existed. There's
prior to
something
the
wrong
issuance of the
somewhere.
document my lord
Something wrong somewhere. It could not have existed on that day.
yes my lord because my lord, the date of the order is 25/9/2017 and my lord the date of evidence my lord as per my record my lord is my lord 21/2/2017 and it was cross-examined on my lord 28/3/2017
Correct.
all the dates are my lord prior to the order of the Jawamandi my
This
lord.
did not exist.
Well, this- Okay, I'll give it to you later. What is there? Along with the secret, what is-
No, we don't know whether this is not there in the opinion also.
In the opinion, also, my lord, it has not been discussed.
It's not there.
Just not how it comes. Because in exhibit, my lord.
This is something which happened in that movie. Back to the Future.
My lord, it was even not my lord, provided
to
to
the
me
future.
also, my lord. That Jamabandi is not provided to me, my lord.
Because in exhibit A, my lord, put in original, then signature of the member is there. Exhibit B, put in original, seal and signature is there. In C, put in original, seal and signature is there. But here it is not. I don't want to comment from that.
The document has been exhibited prior to the issuance of that, my lord.
It is not exhibited.
So not
It's in the
exhibited, but
record.
it's brought on record.
It should not
Somehow
have
it
been-
is,
It should
it
not
has
have been
been
the
brought on
record also,
record.
my lord.
Okay, we'll consider in pass orders.
My lord.
That is why in the morning also we commented. At times, what happens is that we don't scrutinize the document so closely, but when you take it in the chambers and then read it, something strange comes out, and then
Yes.
today morning also it happened.
This document was
Yesterday,
not provided to me also, my lord.
yesterday we took a file inside and then we read it, something else came out. Very difficult.
Oblige, my lord.
That's why Mr. Payang,
As the but the father's name mentioned in the mother. For instance, so this is not necessary. This which is other param or something. The fact is, would put as really. What you will find this is
some of the parties,
Pali Bili. Pali Bili.
RUPALI.
Pali Bili. 12, 13 and 14.
What does it say?
I like. Here, if we can accept such an unreasonable argument and pass on behalf of the petition. I think of this person mentioning therein person to be son or daughter of the son of the person. Not be considered proof of the fact that the son, daughter of the person. This is mentioned in the notice only for the purpose of identification of the notice and service of notice. Certainly cannot be taken as proof of the notice. In the son or daughter of the person, the information can be obtained from the notice herself or from some other documents or sources, but there is no proof of the fact. This is particularly so the context of section 9 of the Foreigner Act 1946, which has been explained in detail by the Secretary of British. My lord, because my lord, para 41 and 42 of the Sovereignty Symbol 1. There, my lord, these informations are collected prior to the 1960. Were my lord, functioning from 2015. Prior to that, these were under my lord, IMDT. And these two forms belongs to the IMDT my lord, rules. And the Honorable Apex Court, Sovereignty Symbol 1 in para 41, it is clearly stated. Whatever information is to be collected by the police officers or by the investigation officer as per this form, those are ultra virus. Those information never did the foreigners who come to India, they will never provide this kind of information to the police officers. This is para 41, 42. So the court cannot, the tribunal or anybody cannot compel the police officers to collect these materials. What my learned friend is arguing, part 1 and part 2 documents are interrogation report and information collected from the procedure itself. So whatever she has given, those has to be recorded in those documents. And on the basis of those, the report is prepared. So if she gives a false name, it is not possible on the part of the petitioner, police officer, to say no, she is not the daughter of that person. So these are the information given by the proceeding at the time of my lord interrogation or at the time of collecting information from the proceeding. So notice and these documents contain the my lord, information what is given by the proceeding only. So it is not proof of any fact. If it can be accepted that whatever stated by the my lord, so whatever is given there in the police report is correct or 100% my lord, is to be accepted, then they have to accept that they are foreigner because there is if doubt is created that he seems to be foreigner. So it is only for the my lord, initiation of the case. It is the proposition laid here. It is for the notice purpose. My lord, this has been given. They have to prove their case by their own under section 9 of the foreigner. Put it your lordship make I got that my lord, 1005 virus. 1005 5 is 5. Around 41 onwards, 41, 42. Could be 6 also. Ultimately, the honorable apex court has said, para 83, all these different ambiguity, order, act, some other virus has been set aside. So now it is, in fact, my submission will be better. These documents are not mandatory at all. Commission's the petition report, the form of my lord, form A, form 1, form 2 are not necessary. But these investigations are of my lord IMBT. Those were done in the period time when IMBT was there, and those has been my lord transferred to foreigners tribunal after the Sovereign was 2005. So those will remain the part of the record. That will be- that will be passed. Of my lord. Remain the record.
The investigation report is not prior to, prior to Sarbananda Sonowal, my lord. Sarbananda Sonowal is 2005, and the report is of, my lord, 15/9/2008.
Not mandatory now.
Okay, we'll consider it.
My lord.
Very much. That is part of the IMDG. That is part of the IMDG. These two forms are part of the IMDG. IMDG. These are not part of the foreigner. For foreigners. Why I want to. Consider find this form one. First tribunals, the immigrants in 1980. Form one and two. This, in fact, this procedure would not have been followed, but this procedure has been followed by the, and this is set aside by. Last piece. Very good. And we did, and we did. I have.
In that
It's
case,
as per rule format. Yes, on the basis, the rule for it, academic. On chart. And that form is followed in Marathi. Everybody. That is good form one and form.
1, 2, 3. Infamous.
Both these are part of the curriculum. Format. Has been set aside by the apex court. Now 41 is over.
In that case, the entire reference will be vitiated. On the basis of a non-existing reference, the proceeding was initiated against the petitioner. There is no other reference.
Mandatory as.
No, no,
You
they have to,
suspect is in as per section 3. Foreigners.
they have to come to a reasonable conclusion that the petitioner is a suspected foreigner. That reasonable conclusion must be there, my lord, in the reference. And there is no reference apart from the forms, my lord. And if these forms are not considered, then the entire proceeding is vitiated. Yes, yes, that can be made, but that has not been made in this case, my lord.
As per 1964 only this way. Only thing is that this format is not.
Whether it is there in the record that the reference has been made as per the foreigners tribunal order.
Yes, as per tribunal. So that
If there is a reasonable conclusion
And-
in that.
melody.
Mr. Payak, then we'll put the state to notice and hear the matter on this. You see, you have a copy of this foreigner's order. This one, foreigner's order. Just take this. Your book is there. You take it back. Yes, 1964. Now you see section 2. The central government or the state government and the union administration or the district collector or the district magistrate may by order refer the question to whether he is a foreigner or not to the tribunal. Now, whether it includes superintendent of police border.
Whether it is like by the central government. But the power and trusted to the central by the central government. There is a notification now.
19. No, that empowerment,
Notification, sir.
but that empowerment must have been made under the IMDT Act,
Why not?
under the Foreigners Act. Then he shows we'll take it up day after tomorrow. We'll put the state to notice. Because once a question is raised about the validity of a reference, we'll decide that. You have it? Okay, send it in by email.
Finally, there was the paragraph 8 of my writ petition also, my lord. Paragraph 8 of my writ petition also, my lord.
What is that?
Wherein I have mentioned that before referring a case for deciding whether a person is foreigner or not, my lord, state has to come to a conclusion that he is a foreigner. State has to come to a conclusion. That conclusion must be.
No, that is there. That is recorded.
Yes.
That is recorded. Because the LVO also gives a report that I have gone through, the SP says, I have gone through the report and physically verified as so and so Beva is to be a foreigner and entered into India illegally after 25/3/1971. It's a clear-cut note.
This is the reports.
Hmm?
On basis of that conclusion is the reports, my lord, which is there in the, my lord.
Yes, you
IMDT
see
Act.
it. Form 1, it contains that endorsement. It has it. Just show it to him. That's it. Show it to him. Mr. Saikia.
My lord, I was saying, my lord, we have made the reference, my lord, the superintendent of police, my lord, border, have made the reference on the form which is under the IMDT Act, which has already been, my lord, set aside by the Honorable Appeals Court.
It doesn't help the petitioner in any way. You see, mere use of a form, which is not a prescribed form, that does not vitiate an administrative action.
But my lord, the forms are, my lord, part of the IMDT Act, which is not.
No, it's
Here.
okay, but you see, that doesn't vitiate. For the purpose of vitiation, we'll need something more than that.
And this is the
And let us see what is the notification.
Para 42 has said is informations never be positive. Well, so this is not is not it's the language of paragraph. Because a person who has come from another Bangladesh will not say, if I go that I am coming from Bangladesh, I have come on this information will not disclose. So it cannot be burden to the or investigate must collect this informations. That's why this form is
In that case, everyone, they can make a reference against everyone, man,
that is the-
without any logical conclusion,
So we reserve a comment, we don't make that comment. We'll decide it when the matter comes. Because our opinion would not matter.
Yes,
Certain things we will have to reserve
My lord.
for writing in the judgment. It's very difficult for a court to make casual comments. It may be blown out of proportion.
This case, my lord, what I have found, my lord, though, my lord, the Jawabandi was not properly exhibited, not exhibited at all, if I say, my lord. Even, my lord, Jawabandi is, my lord, Lordship is aware about the Jawabandi, that the Jawabandi is existing as on date. Now, this is a writ proceeding, my lord. Lordship may take into consideration the Jawabandi also.
No, you see, when you are making that statement, many things roll out in the
Because
mind.
if
Number one,
citizen, if, my lord, making a
I will
person,
tell you,
my
we'll
lord,
explain it to you.
to be citizen of
You
the
see, we know the parameters of additional evidence. Ibrahimuddin, 2012 8 SCC is one. How and under what circumstances a new document can be looked into is again a subject matter of various judicial authorities on the point. We have our limitations in exercise of jurisdiction under certiorari. Therefore, how far we can make an observation on a document which is not exhibited. We
What I am
will have
saying,
to
my lord,
hear on that.
citizen should not, my lord, be deprived from his right. That is my submission before Lordship. Because it is before a Lordship that she is the daughter of Bharanal Sheikh. He has inherited the property which was in the name of her father.
No, father is only a declaration. There's no document to connect you to make the projected father a father.
My lord, if as my friend said, that
No, you see these documents in public domain. You may have the document of the highest executive in the country, land document.
my lord,
It is available in the public domain. So if extracts that, will it make him the son or daughter of that personality?
it is their case. It is their case that I am the daughter of Haranal Sheikh. And on the basis of that particular report only, my lord, the reference was made. If they disown that particular, if they disown the, my lord,
Just a moment.
investigation,
Mm. This is it. Put it, huh? Please put it. I think it takes some time. Deciding because. Submissions of. You see, all sides are represented. The submissions of Mr. Ayat Saikal and counsel for the petitioner, as well as Mr. J. Paik and standing counsel for the orders for the Home Department is concluded. Just been reserved. Order reserved.
Political tribunals existed in the 1960s. Prior to IMDT. When IMDT came, my lord, those were In it came back after 2000. No students. This. That's why these notifications are of matter prior to my time.
You'll have to rise for the single bench.
Where we get to that door 3 also. Some more time to get the instructions of the forward.
Yes.
More time. was it? Then how many will also? 10 days time. Lord. Yes. Lord. It's a after 10 days. Single madam.
Single review. That's it. That's it. Loss. Loss. Sorry, interim order. Lost. That's it. My appearance may be marked loss. I am for the review petitioner. That's it. Obliged.
May I please, your lordship, I beg to mention item number 1 and 2. Your lordship may adjourn the matter for the day and list again after 2 weeks. Hmm. Stay.
Government advocate. You are appearing in which matter?
For 1 and 2. Before Hedaya Begum.
No.
I don't know.
This IA is in 4828.
WBC is 4828.
Yes, silent. Photo থাকিব পাৰে তো। Just find out senior government advocate.
Lordship.
Just find out senior government advocate.
Senior advocate.
Mr. Dinath. Government advocate. Just find if somebody is there, call in the court.
What is Indicably.
Just wait, let somebody come.
Sure.
Yes, in the meantime, we'll take up item 4. Yes.
Lordship, on last date, Lordship, I was reading my first allegation that was regarding suppression of the 3 affairs pending against the the return candidate, Lordship. Lordship, I was at
Page 21,
page 21, Lordship.
para 14A to C.
Yes, Lordship, today I am reading from paragraph 14D, page 23. That is my second allegation, Lordship.
Page
23.
yes.
Lordship, that other than the affairs pending against the respondent herein also failed to fully disclose about the details of his movable and immovable assets. In clause 7A of form 26 at serial number 6, details of motor vehicles, aircraft, yachts, and ships owned by the candidate and his spouse is required to be given by the candidate. Such details should also contain make, registration number, year of purchase, and amount. The respondent herein is in his election affidavit, form 26, disclose about 4 vehicles owned by him, which are aged 11 age. So and so this numbers of the vehicles are given, Lordship, but deliberately not disclose the year of purchase and the amount at which the vehicles were purchased. He only mentioned the value of the vehicles as rupees so and so, which is far below the current market value of the said vehicles. Same is the case with the vehicles owned by the spouse of the respondents. She also mentioned about one Endeavour car, AS 11L786, rupees 29 lakhs 99,000, which without giving the details like year of purchase and the price of the vehicle. The candidate had failed to furnish such information as sought for on the pro forma given to him, and the returning officer also failed to discharge his statutory duty power of returning officer for not holding proper scrutiny of nomination paper. No proper scrutiny of the nomination paper was done under section 36(2) of the Act, which certainly rendered the nomination paper suffering from defect of substantial character, and the returning officer was within his right rejecting the same. 14E. At clause 7B, details of immovable assets at serial number 2, non-agricultural land, the respondent failed to disclose the detail regarding any investment on the land by way of development, construction, etc. The respondent mentioned rupees 00, meaning thereby that no investment was done either by himself or his spouse. However, at serial number 4 of the same clause, it is clearly mentioned that a building of 2,200 square feet is located on that plot of land. Lordship, may kindly look at clause 7B, Lordship, of the affidavit, Lordship. That affidavit start from page 65.
65.
Yes, page 65. And clause 7B is at page 73, Lordship. Page 73, details of immovable assets. Lordship, may kindly see small Roman number 1 of the first column, description.
Yes,
So this is regarding agricultural land lordship.
yes,
Next at serial number 2, it is non-agricultural.
yes.
Non-agricultural land lordship may kindly come to next page lordship, second column. Second column. Any investment, first row, second row, third row lordship. Third row, any investment on the land by way of development, construction. So it is written as 00.
Yes,
But if lordship comes to next page lordship, serial number 4, Roman 4. Third row lordship, built up area total measurement in square foot. It is shown as 2,200 square foot. So one building is situated on the same plot of land. No development cost has been shown, but actually one building has been erected there without any investment. Exactly on this point, lordship, I'd like to place one judgment, lordship, very recent judgment passed by the Honorable Supreme Court. This is 2024 SCC online, lordship. 2024 SCC online SC 25448.
just a moment. What is the citation?
2024 SCC online SC 2548. 2548. This is Kimnu Haukip Hangsing versus Ken Raikhan. I'm citing paragraph 7 to 12, lordship.
You have a copy, please give it. It's not opening.
2024
It's not
SCC
opening.
online. Lordship.
It is slow for some reason. What is the name of the parties?
KIMNEO, Kimneo,
AI
M for Mumbai,
uh,
NEO.
NEO.
Yes, Lord. Kimneo, Haokip, HAOKIP. Kimneo, Haokip, Hangsang, HANGSHING.
AIMNEO.
KIMNEO, Kimneo, Haokip, HAOKIP, HANGSHING. Lordship, kindly see paragraph 8 for now, Lord.
It's not opening.
Only paragraph 8. Paragraph.
Yes. Little.
Then, Lordship, I am coming to paragraph 14F, page 24, Lordship. That at clause 9B of the 9B, the candidate requires to give details of contract entered into by the candidate or his spouse or by a partnership firms and private company in which the candidate or spouse are partners or shareholders with reference with appropriate government and any public company or companies at serial numbers A to F of the said clause, that is 9B, the response of the respondent is nil, meaning thereby that he or his spouse never entered into any contract with any appropriate government and any public company or companies. It is stated that such statement made by the candidate in his election affidavit in Form 26 is entirely a false statement, which is evident from the details given by the candidate himself in his affidavit at clause 7A serial number 5, that a bill amounting to rupees 7,99,34,327 is receivable by him by him from HPC. Similarly, a bill amounting to rupees 3,10,28,883 from HPC has also been shown by the spouse of the respondent. It is well known that The respondent is a contractor and supplier of Hindustan Paper Corporation Limited, which is a central government undertaking. Lordship, that's clause number 7A I have referred, Lordship. Lordship will find that at page 60. Page number 71, Lordship. Page number 71, fourth row.
Page 71.
Page 71, fourth row, that is Roman, small Roman 5. Personal loans, advance given to any person or entity, including firm, company, trust, etc., and other receivable from debtors and amount. Receivable from debtor HPC, Hindustan Paper Corporation, against firm MSS Enter ENT, rupees 4 crore 74 lakhs 40 rupees 4 crore 47 lakhs 44,858, and bill receivable with HPC amount rupees 7 crore 99 lakhs 34,327. This is for himself, Lordship, and next column is of the spouse, Lordship. Then if Lordship comes to page 78, Lordship.
No, this page 71, what you're trying to show?
Lordship, here, that is what I'm trying. So at page 78, at serial number 9A, his answer.
78.
Page 78, serial number 9A. Lordship, may kindly see 9B.
70.
At 78, Lordship.
Yes.
78, 9A, detailed source of income.
Yes.
Here he has trade license holder, he has shown. Spouse is also same Lordship. 9B, Lordship, contracts with appropriate government and any public company or companies. Details of contract entered by the candidate, nil. Details of contract entered into by spouse, that is also nil. He is showing that he is to receive rupees such and such from HPC or from some contracts, Lordship. But in this column, he is shown as nil. So this is separation of facts, Lordship. Details of contract entered into by the dependents, that is not relevant for in this purpose, Lordship. But A and B. Am I clear, Lordship?
Yes.
Then serial number 15, Lords, paragraph number 15, 25, page 25.
Would you tell us, in this regard, the submission of Mr. Pathak was
Lordship.
that if I am receiving any money from someone, and if it is not an existing contract,
Lordship.
then how would it would be material?
So here the query is not existing or past contract, Lordship. Here the clearly asks contracts with appropriate government, any public company or companies. And receivable means the relationship with the government company still exists. Lordship, that amount has not yet been received by me. I am yet to receive that amount. That is my relationship with that company is still going on. This is existing relationship between the person concerned and the government entity, Lordship. That is what my submission, Lordship.
No, but if there is no disclosure of contract,
I understood, Lordship. Lordship is saying probably this amount relates to a contract which was prior to his filing of the nomination paper. But it is not cleared here, Lordship. And in this case, if it is receivable, it's an ongoing relationship still there, Lordship. That is why it is receivable.
okay.
Paragraph 15, Lordship. That the aforesaid page 25. That the aforesaid commission of the corrupt practice of non-disclosure about the affairs pending against him and the non-disclosure of the full details about movable and immovable assets in his election affidavit filed on 11/3/2021 by Nizamuddin Chowdhury, the returned candidate respond on 11/3/2021, that is on the date of swearing the election affidavit, has rendered the election of the election candidate herein number Algapur legislative constituency liable to be declared void. 16. That the material facts and particulars adduced herein above disclose a clear case of commission of corrupt practice of non-disclosure of criminal antecedents and the non-disclosure of detail about movable and immovable assets as provided under section 123(2) of the Representation of the People's Act by the returned candidate respondents with the full knowledge of the returned candidate respondent, thus entailing a declaration under section 101B of the Act that corrupt practice of the non-disclosure of criminal antecedents has been committed by the returned candidate respondents with a further declaration under section 101B declaring the election of the returned candidate respondent number 8 Algapur LSE to be void. Then, Lordship, I am coming to page 31, Lordship. Page 31, paragraph 21.
Yes.
Page 31, paragraph 21, that it is very much pertinent to mention at this stage that the actual name of the respondent herein is Nizamuddin Chowdhury, Nizam. In the election affidavit also, the respondent herein signed as Nizamuddin Chowdhury, same spelling, Nizam. However, he filed the nomination as Nizamuddin Chowdhury, Nizam. In the list of contesting candidates and in the ballot papers also, the name of the respondents is written as Nizamuddin Chowdhury, Nizam. Further, in the certificate of election issued by the returning officer, number 8 Algapur LIC. The name of the return candidate from number 8 Algapur LIC is written as Nizamuddin Chaudhary, NIJAM. Most pertinently, the returning officer, while accepting the nomination paper of the respondent herein, mentioned his name as Nizamuddin Chaudhary, NIZAM. However, to the information of the petitioner, till date, the respondent herein has not initiated any process for correction of his name in the certificate of election. In fact, this very fact also highlights the level of sincerity shown by the respondent to maintain the sanctity of the election affidavit in Form 26, as well as the carelessness shown by the returning officer concerned while discharging his duty entrusted upon him under the Act to maintain vigil while accepting the rejecting the nomination of the candidate. The subsection 4 of Section 33 provides, on the presentation of the nomination paper, the returning officer shall satisfy himself that the names and electoral roll numbers of the candidate and his proposer as entered in the nomination paper are the same as those entered in the electoral rolls, provided that no misnomer or inaccurate description or clerical, technical, or printing error in regard to the name of the candidate or his proposer or any other person, or in regard to any place mentioned in the electoral roll or the nomination paper, and no clerical, technical, or printing error in regard to the electoral roll numbers of any such person in the electoral roll or the nomination paper shall affect the full operation of the electoral roll or the nomination paper with respect to such person or place in any case where the description in regard to the name of the person or place is such as to be commonly understood, and the returning officer shall permit any such misnomer or inaccurate description or clerical, technical, or printing error to be corrected, and where necessary direct that any such misnomer, inaccurate description, clerical, technical, or printing error in the electoral roll or in the nomination paper shall be overlooked. So this is the provision. Clearly, Section 33(4) casts a duty upon the returning officer to apprise the candidate to cure the defects which are only clerical, technical, and suggest the printing error in regard to the name of the candidate or her proposer, and where necessary direct that any such misnomer, inaccurate description, clerical, technical, or printing error in the electoral roll or in the nomination paper shall be overlooked. In the instant case, neither the nomination paper was properly scrutinized to find out that the name of the candidate was wrongly written, nor the name of the corrected, and nor the name was corrected. And above all, no direction was passed by the returning officer to overlook the error in the nomination. The record relating to the filing of the nomination by the respondent will substantiate such improper acceptance of nomination filed by the respondent's returning candidate. It is stated that the voters who are not aware about the fact that Nizamuddin Chaudhary and Nizamuddin Chaudhary spellings are different are the names of the same person might have voted for Nizamuddin Chaudhary thinking that they are voting for Nizamuddin Chaudhary and they are not for Nizamuddin Chaudhary. I'm just referring to the spellings, Lordship, Nizamuddin Chaudhary. Because of such confusion, if even one vote has been casted in favor of the Nizamuddin Chaudhary, which actually gone to Nizamuddin Chaudhary, it is sufficient to hold that the election of the respondent herein has been materially affected. Accordingly, it is submitted that such improper acceptance of nomination filed by the respondent return candidate has materially affected the election insofar as election from number 8 Algapur LIC is concerned, which is liable to be declared and struck down by this honorable court. Lordship, on this point, Lordship, an argument was advanced by my learned senior colleague that in how and what manner the change of name, Lordship, has materially affected the election that has not been explained. Lordship, on this point, Lordship, I have one judgment to place, Lordship. 2018 4 SCC 1. 2018 14 SCC 1. I'm sorry, Lord. 14 SCC 1. At this stage, Lordship, I am referring to only one paragraph, that is paragraph 53.
2018,
2018 14 SCC 1. Three judges bench.
paragraph.
Paragraph 53, Lordship. '53.
Yes.
In para 23 of the judgment of Moirembam Prithviraj, after analyzing the exposition in Durai Muthuswamy, the court observed thus. 23. It is clear from the above judgment in Durai Muthuswamy that there is a difference between the improper acceptance of nomination of a return candidate and the improper acceptance of nomination of any other candidate. There is also a difference between cases where there are only two candidates in the fray and a situation where there are more than two candidates contesting the election. If the nomination of a candidate other than the returned candidate is found to have been improperly accepted, it is essential that the election petitioner has to plead and prove that the voters polled in favor of such candidate would have been polled in his favor. On the other hand, if the improper acceptance of nomination is of the returned candidate, there is no necessity of proof that the election has been materially affected, as the returned candidate would not have been able to contest the election if his nomination was not accepted. Now, if lordship comes to page 65, lordship, that is the document I am referring to.
Yes.
Page 65.
Yes.
Page 65, lordship, may kindly, this is the form 26 affidavit, lordship. This is the requirement of rule 4A.
Yes.
Lordship, may kindly see the second paragraph, I Nizam. Nizam. On top,
Yes.
lordship, may kindly see his signature, Nizam.
Yes.
Lordship, every page of the affidavit has been signed by the same spelling, Nizam. Then lordship, it comes to page 101. 101 is nomination paper, lordship. In the nomination paper also, his name has been spelled as Nizam.
Yes.
Next page, lordship, 102. In the second half, Lordship, part 3, D, 1D, small d. Lordship, may kindly see the declaration. My name and my father's, mother's, husband's name have been correctly spelled out above, name of in the language.
Yes.
Lordship, next page 103, Lordship will again see his signature as NIZDM. Page 105, Lordship.
Page 103.
103 is his signature, Lordship. Lordship, above is the declaration. Page 102 is the declaration that his name has been correctly spelled in the nomination paper, but he signed his name as NIZAM.
Yes.
Next, page 105, Lordship. Page 105, NIZAM. This is the return certificate of election. It was issued on 2/5/2021, that is after election.
Yes.
But Lordship, till date, he has not applied, as I have explained in my petition, Lordship, for correction of his name, Lordship. So basically, these are my allegations, Lordship.
Yes. That's all.
Yes, Lordship. I'm just placing 2-3 judgment. Lordship, one judgment I am taking, Lordship. This is 2012 8 SCC 706.
Mr. Nayak, at the end of the day,
Lordship,
you just give the list of judgments on which you are relying.
Lordship,
I may have missed one or two, but
I,
just give a list.
Lordship.
Yes, what you're citing now?
2012 8 SCC to 8 SCC 706.
Para?
Just 2-3 paragraphs, Lordship. Paragraph 13, 14, and 15. Just 2-3 lines, Lordship.
Yes.
In paragraph 14, Lordship, it is stated in the middle portion, Lordship, cause of action. It does not comprise evidence necessary to prove such facts, but every fact necessary for the plaintiff to prove to enable him to obtain decree. So these are not to be seen as evidence, Lordship. Whatever allegations I have placed, Lordship, and whatever documents I have annexed, at this stage, Lordship, of considering an Order 7 Rule 11 application, it should not be considered as an evidence.
Yes.
Another allegation means argument was there that there are some defects in my affidavit and in verifications, Lordship. So that argue to counter that argument, Lordship. My submission will be there. The next citation, Lordship, 2020-7 SCC 366.
Twenty
2020-7 SCC 366
360
366.
366.
Paragraph 23, Lordship.
Yes.
I'm reading only one line from paragraph 23.12. That line is, if the allegations in the plaint prima facie show a cause of action, the court cannot embark upon an inquiry whether the allegations are true in fact. That one line only, Lordship. Lastly, Lordship, one judgment I am referring, Lordship, this is the Supreme Court judgment on in Karimuddin Barbia Aminul Haq Loscar. Lordship, this is a judgment here. Your Lordship was pleased to dismiss one Order 7 Rule 11 application against this challenge was made before the Supreme Court. Lordship, in paragraph 19 of that judgment, Lordship. Supreme Court was pleased to dismiss this appeal, Lordship. And the ground taken by the Supreme Court.
Para 19.
Yes, Lordship. Now, from the bare reading of the election petition, it emerges that the respondent number 1 has made only bold and vague allegations in the election petition without stating the material facts in support thereof. Lordship, that was the ground on the basis of which Supreme Court was pleased to dismiss the application, Lordship, dismiss the appeal, Lordship. Lordship, in my humble understanding, Lordship, in our application, in our petition, we have furnished enough material, Lordship. First of all, Lordship, we have annexed those affairs, Lordship. These are certified copies of the affairs that are pending against the petitioner, a respondent, Lordship. So these are basically my submissions, Lordship. And I pray your Lordship, Lordship will grant my application, Lordship. But I mean, prayer, Lordship, for rejecting the Order 7 Rule 11 application. Obliged, Lordship.
Please give a list of books again.
Lordship, I will.
Yes, Mr. Kalita. You close it. Mr. I, Kalita, learned counsel for the petitioner is present. The submissions of Mr. P. Nayak, learned counsel for the opposite party, is concluded. Order reserved. I hit.
Item 1 with 2.
Government advocate is not there. Am I?
Your Lordship, we tried looking for the other side, but he's not available.
Your name?
Mr. Zedej Bora. Mr. Zedej Bora.
You are on behalf of?
I'm on behalf of Miss S.K. Nargis. Miss S.K. Nargis. On behalf of S.K. Nargis.
Okay. On the prayer made by learned counsel for the applicant, the matter stands adjourned today. There is no representation from the respondents. List after 2 weeks on a date to be fixed by the office. Registry.
Most obliging.